Hello and welcome to this week's edition of Chaile Time. So this week we are continuing with our 2-episode series on retrenchments or dismissal based on operational requirements of the employer. So we're dealing with Section 189 in the LRA here. So last week we touched base on the small scale retrenchment, the normal Section 189. And this week we're going to highlight the key differences between the small scale and the large scale. So we're dealing mostly with Section 189A this week. So just to recap quickly, the foundation is the same. There must be a joint consensus seeking consultation process. Now, just to highlight quickly in terms of Section 189, what the key factors of consultation are, it's the following. Number one, the reasons for the proposed dismissals. This you'll find in Section 189, okay? The alternatives that the employer considered before proposing the dismissals and the reasons for rejecting each of those alternatives. The number of employees likely to be affected and the job categories in which they are employed. The proposed method for selecting which employees to dismiss. The time when or the period during which the dismissals are likely to take effect. The severance pay proposed. Any assistance that the employer proposed to offer to the employees likely to be dismissed, the possibility of future re-employment of the employees who are dismissed, the number of employees employed by the employer, and the number of employees that the employer has dismissed for reasons based on its operational requirements during the preceding months. And then subsection 6 here, the employer must consider and respond to the representations made by the other consulting party, and if the employer does not agree with them, the employer must state the reasons for disagreeing. And as I mentioned last time, that typically employees make the mistake here, they do not consult back, they do not make recommendations. And if they do, the employer is compelled by the law to give good reasons why they are rejecting them, if they do. Okay, so this week, Section 189A, the large-scale retrenchment. In a nutshell, the big difference is that Section 189A is much more regulated, especially from a procedural perspective, whereby the Section 189, the small scale retrenchment, is not really highly regulated. There's no timeline, for instance, in terms of how long the consultation process must be. But it starts off with a criteria as to when it applies. I did mention it last week, but let's just go again, okay? So a large-scale retrenchment, in terms of the procedure of Section 189, capital A, is only triggered based on the following calculation. This section applies to employers employing more than 50 staff. So if your company employs less than 50 staff, Section 189, capital A, the large-scale retrenchment will never apply, okay? But okay, so now let's just presume that it is, okay? The employer contemplates dismissing by reasons of its operational requirements at least 10 employees if the employer employs up to 200 employees. So you can employ more than 50 staff, but if you retrench or anticipate to retrench less than 10 staff, there's no large-scale retrenchment there, okay? The second category, if you plan to retrench 20 employees, if the employer employs more than 200 but less than 300 employees, then the scale aggravates. 30 employees, if the employer employs more than 300 staff but not more than 400 employees. Then 40 employees, if the employer employs more than 400 but not more than 500 employees, or 50 employees if the employer employs more than 500 staff. So basically, if your company employs more between 300 and 400 staff and you're anticipating retrenching less than 30 staff, then it is not a large-scale retrenchment. It must be at least 30 staff. If you plan to retrench at least 30 staff, if you employ between 300 and 400 employees, then the large scale will apply. Interesting also here, subsection B, the number of employees that the employer contemplates dismissing together with the number of employees that have been dismissed by reason of the employer's operational requirements in the 12 months prior to the employer issuing a notice in terms of Section 189, subsection 3, is equal to or exceed the relevant number specified in paragraph A. So you will take into consideration the period of the last 12 months, how many staff were retrenched, and include that in the calculation in order to determine as to whether your new engagement qualifies in terms of Section 189A. Now, just remember the Section 189 subsection 3 notice. You can recall from last week. If you have not seen last week's episode, go back and have a look at it. that is the document. It's an invitation notice that sort of triggers and kicks off, that starts the whole retrenchment consultation process. So one of the key differences is that you will find that in terms of the Section 189 capital A process, the large-scale retrenchment process, is that either parties, either the employer or the employee party, may request facilitation by the CCMA. So the employer can, in the Section 189 subsection 3 invitation to consult notice, stipulate there whether they want to have facilitation or not. It's not compulsory that they must have facilitation, but it's up to them. The employee party, if the employer did not require facilitation, the consulting parties representing the majority of the employees whom the employer contemplates dismissing have requested facilitation and have notified the Commission within 15 days of notice. So you must just be alive to this, that if the employer in the Section 189.3 notice did not request facilitation, you as the employee party have 15 days to request facilitation. Now, facilitation, in a large-scale retrenchment, the employer basically cannot terminate contracts of employment in 60 days. There's a bit of an anomaly there. We'll touch base on it now, but in principle, can't retrench within 60 days after issuing the Section 189.3 notice. And a CCMA commissioner will probably facilitate 4 sessions before you conclude the process and therefore can retrench staff. But now, what happens when a facilitator had been appointed in terms of when can you terminate contracts, or when can you terminate contracts if a facilitator had not been appointed? Okay, so Section 189A subsection 7 deals with, and subsection 8 deals with this. So firstly, if a facilitator is appointed in terms of subsection 3 and 4, and 60 days have elapsed from the date in which that Section 189 subsection 3 notice was given, A, the employer may give notice to terminate the contracts of employment. So after 60 days, regardless as to whether the facilitation process had concluded, the 4 consultations as an example, if 60 days had elapsed since issuing the Section 189.3 notice, the employer may terminate the contracts. That is, if a facilitator had been appointed. Now, a registered trade union or the employees who have received notice of termination, so once the employer now, when a facilitator had been appointed, once the employees or their representatives received notice of termination of the contracts, the employee party have one of 2 options. Either they can give notice of a strike in terms of Section 64, subsection 1 of the LRA, or, not and, or refer a dispute concerning whether there is a fair reason for the dismissal to the Labour Court in terms of Section 191, subsection 5B. Section 191, subsection 5B basically say that dispute resolution recourse, a party must refer a dispute to the Labour Court if the reasons for dismissal is alleged to relate to the employer's operational requirements. So, after a facilitator had been appointed, 60 days has elapsed, the employer may terminate the contract of employment. Then an employee party got one of 2 options. Either strike, but then you apply in terms of Section 64 of the LRA, or you can go and file for adjudication at the Labour Court, but then you can't complain about procedure really. Okay, and I want to skip a bit here and explain why. So you only complain at the Labour Court about the substance. It's because Section 189, the large-scale retrenchment process, this does not apply to the small scale, the large scale. It's got a built-in mechanism how to deal with procedure. And we talk about subsection 13 here. If an employer does not comply with a fair procedure, a consulting party may approach the Labour Court by way of an application for an order. A, compelling the employer to comply with a fair procedure. B, interdicting or restraining the employer from dismissing an employee prior to complying with a fair procedure. C, directing the employer to reinstate an employee until it has complied with a fair procedure. And D, make an award of compensation if an order in terms of paragraphs A to C is not appropriate. So if the employer is not following the correct procedure, you have to approach the Labour Court in principle to interdict the employer or to compel them to follow a fair procedure. But if they terminate your contracts, either strike or you apply for a case to the labor court, but only as far as substance is concerned. What if a facilitator had not been appointed? A party may not refer a dispute to a council or the CCMA unless a period of 30 days has lapsed from the date on which notice was given in terms of the Section 189.3 notice. Oh, but yeah, it's getting confusing now. Now we're talking about 30 days. So, when the employer terminates the contract of employment after 30 days, okay, only then, after 30 days, can the employee party refer a dispute to the CCMA. And typically that will be in terms of a strike. Okay, so once the periods mentioned in Section 64, subsection 1 have elapsed, the employer may give notice to terminate the contracts of employment, or a registered trade union or the employees who have received notice may then, once again, either go on a strike or file a dispute to the labor court in terms of substance. So once a facilitator had not been appointed and you receive a Section 189 notice, okay, there's a 30-day period, waiting period, before the employees can file the dispute at the CCMA. Once you do, typically for conciliation, another 30 days in terms of the conciliation period in Section 64, subsection 1 will apply, which also then in principle comes to a 60-day period before the employer can actually then go and terminate the contracts. So Section 189.3 notice, you wait a 30-day period, then you can apply for conciliation. You can only go on a strike in terms of Section 64 after another 30-day period lapse. So 30 plus 30 in essence is once again 60. So after issuing a Section 189.3 notice, there's no way an employer can ultimately just terminate contracts without the 60-day period at elapsed. Yeah, then we can continue. So we mentioned Section 13 already. In terms of, interdicting the employer to compel him to follow a fair procedure. And then also subsection 16, the labor court may not make an order in respect of any matter concerning the disclosure of information in terms of Section 189, subsection 4, that has been the subject of an arbitration award in terms of Section 16. And also, an application in terms of subsection 13 must be brought no later than 30 days after the employer has given notice to terminate the employee's services, or if notice is not given, the date on which the employees are dismissed. So you can't wait for either, okay? And then subsection 18, the labor court may not adjudicate a dispute about the procedural fairness of a dismissal based on the employer's operational requirements. So there you basically, in a nutshell, have the key differences. The large-scale retrenchment is a bit more highly regulated. Parties can apply to the CCMA to facilitate the dispute. A CCMA commissioner will typically set the matter down on 4 instances of consultation. In principle, an employer can only terminate contracts of employment after 60 days, at which the employee parties got an option to either file for a strike, go through the Section 64 process, or actually apply for adjudication and refer the case to the labor court on substance. So that's retrenchment. The underlying nature of the retrenchments are the same. It's a consultation process, a good faith process, and there are numerous matters that the parties must consult on. And I want to encourage employees, if you are subject to a Section 189 process, actually consult back, make recommendations, because the employer is compelled by law to provide reasons, good faith reasons why they're rejecting any of the proposals an employee or employee party had made. That's for this week, so see you again next week on It Is Chaile Time.